This is it, the last panel of the day. Insider Trading 360, and we are closing strong with a great panel. Let me introduce our moderator, Dan O'Connor. He is a partner at Ropes & Gray based in Boston, and Dan was previously senior trial counsel at the SEC. Welcome, Dan.
Thank you.
Caitlyn Campbell is a partner at McDermott, Will & Emery based in Boston as well, and she was previously an attorney in the SEC's Division of Enforcement. Caitlyn, great to see you. Next to her is Norman Harrison, Managing Director at Secretariat, based in Washington, D.C. Norman's a former investment banker and transactional attorney. He previously held senior positions at Cole and FTI and was a senior executive at Richard C. Reed and Company. Norman, welcome. To his left is Sarah Levine, a partner at Jones Day in D.C. Sarah previously served as a deputy AG in the Department of Justice and assistant chief litigation counsel in the SEC's Division of Enforcement trial unit, and as a special assistant to the President of the United States and associate White House counsel. Sarah, thanks for joining us. And finally, from the SEC, we have the chief of the Market Abuse Unit, Joe Sansone, who is in the New York regional office. If you don't know, Joe's unit is a specialized group that uses data and analysis to investigate complex insider trading rings and other abusive trading schemes in this country. So, of course, Joe is the man for this panel, and we're really pleased that you're joining us. Dan,
all right, thank you, Bruce. So, all the usual cliches, we're saving the best for last, we're in between you and the bar, so we realize that, so we're going to jump right into it. And Joe, I'm going to flip it over to you so you can kind of give us your highlights of the last year, maybe from your unit, but then really what you're thinking about on a going forward basis with all the caveats that all your other colleagues have had for what they can provide on that future procrastination.
Sure, and before I do that, just the usual disclaimer that the views that I express here today are my own, not necessarily that of the Commission or its staff. But with that said, yeah, I'm happy to kind of dive in, talk a little bit about the year in review and kind of what I see ahead. People often ask about, okay, well, what are the priorities of the Market Abuse Unit? And the way that I think about it is that, yes, we have priorities in terms of the things that we want to look at, but I think maybe more than any other group, our work is driven by what we see in the trading data. And so the priority, in a sense, is to focus on that data and to be open to what we find. And so usually what we find, and especially, so the topic of this panel is insider trading, what we pretty consistently find is insider trading in the same types of events. And it's not that surprising because if you're somebody who has material non-public information and you want to make money, the types of events that you're going to trade in front of are the types of events that move markets. So mergers and acquisitions, right? Earnings, quarterly and annual earnings. For pharmaceuticals companies, it's going to be clinical trial results or perhaps an FDA decision one way or the other, negative or positive. And then you have kind of a host of idiosyncratic events like spin-offs and corporate partnerships and things like that. But those are, the events that you're going to see us bringing cases on. And so those are our priorities. But the priorities kind of come out of the data because we're identifying those suspicious trades and then following up on them. And that's basically what you saw last year, those types of events. The thing that we need to be careful about is that we don't get so tied into looking at a particular type of event that we miss something that's maybe kind of more important. And I think what I'm talking about there is being open to letting the data tell you a different story. And so, what we've seen in some of the cases that we've brought in recent years, like the front-running cases, is that the event is not necessarily going to be a corporate earnings announcement or M&A, but the event is going to be, in a front-running case, trading by another firm. And so one of the bigger cases that we've brought in the last few years was a case, SEC versus Williams and Belemic, which was a front-running case with over $47 million in trading profits. Those happened over time, right? Bit by bit, as the trader traded in front of trades by a large investment manager. So that's kind of sort of principle one is, basically we understand that there are going to be typical events, but not sort of missing out on those bigger cases by becoming too wedded. Similarly, this is kind of the second axis, is thinking about the types of defendants that we're going to have in our cases. And so, other than professional athletes, I think, probably the most ink is spilled on cases against CFOs and CEOs, right? The people at the very top of the chain. But of course, insider trading happens all up and down the chain. And so we have to be focused on that, and also focused on the idea that trading can happen outside of that outside of that chain. So, and recently, and this is a case that we brought last fall, trading by an employee of the Federal Reserve Bank of Richmond who was obtaining inside information as a result of his job as a bank supervisor and traded in front of quarterly earnings announcements by banks. And so we don't want to miss those cases, right, by becoming kind of too focused on a particular, type of event or a particular type of defendant. And, similarly, another case that we brought kind of toward the end of last year is hacking. So, right, not technically insider trading, but we have to be open to the idea that the person who's trading on material non-public information might not be an insider at all. They might be a hacker who hacks into a company, and we brought a case, SEC versus Westbrook, that alleged that he had hacked into 5 different companies and traded in front of 14 earnings announcements. So I'll stop there. That's kind of a little bit of an overview of the year. Not too different from what we've seen in the past. And I expect that will continue going forward.
Okay, all right. Yeah, one of the areas that's gotten a lot of attention over the last year is shadow trading. With the Panawat case finally going to trial, realizing it's, there's some work left there. And there's also been some press covering the Arista Networks CEO case as maybe shadow trading 2.0. Maybe start with you, Joe, talk a little bit about, how you're seeing those cases develop, if at all over time. Is that just such a novel theory that the new administration might not accept it, or what you're expecting in that regard?
Sure. I mean, I think most people are familiar with the Panawat case. I don't know how much time to spend on it. I'll just say very briefly, the issue that we're talking about is in the Panawat case, you had an employee of the company Medivation, which was on the verge of being acquired by Pfizer. He worked on the deal, received an email that the deal was about to happen very shortly, and minutes after obtaining that information, traded short-dated out-of-the-money call options, not in Medivation, his own company that was about to get acquired, but a peer company called Insight. And when the deal was announced, the price of Medivation went up. Of course, the price of Insight also went up, and he made a little over $100,000. That case was filed in 2021. The SEC defeated a motion to dismiss in 22, a motion for summary judgment in 23, and then the case went to trial last year, and the SEC secured a verdict against Panawat for insider trading, and that's kind of where we are right now on that case. So I don't know if others wanted to comment on that.
Yep. And the Arista Networks case, and getting ready for this, we talked about that because there is, that's been seen by some as another variation on the shadow trading. You want to comment on that a little bit?
Right, sure. So that case involved SEC charges against an individual named Andreas Bechtolsheim, and he was the founder and chairman of Arista Networks. He traded based on information that he received about the upcoming acquisition of a company called Acacia. The way that he received that information was that he had a long-standing relationship. Arista and Bechtolsheim had a long-standing relationship with a technology company, and he was called by a manager at that company to say that the company had information that this acquisition was about to happen, and to try to kind of evaluate the meaning of that for this what we call in the complaint technology company A. And so, we allege that he misappropriated that information to trade on the securities of Acacia, which is the company that was about to get acquired. I don't really see this as sort of parallel to or the same as the Panawat case. I mean, the most notable difference in my mind is that Panawat traded on the securities of what we sometimes refer to as a substitute security. So not the company that was about to get acquired, but a similar peer company whose stock price might also respond to that announcement. And in the Bechtolsheim case, he traded in the securities of the company that was about to be acquired. So that to me is really more in line with cases that we bring all of the time. I think maybe the thing that's a little bit different about it is that the company that reached out to Bechtolsheim, what we call technology company A, was not the company that ultimately acquired Acacia. It was acquired by Cisco. So, maybe a little bit of a sort of difference in the fact pattern from what we normally see, but I don't view it as kind of trading in a substitute security in the same way that Panawat did.
Okay. So Norman, in thinking about the compliance side of this, after reading the Panawat case, I mean, a lot of us, I don't think Joe would exactly say this, but a lot of us might say that the company there kind of established policies and procedures which laid the groundwork for that case. Without those kind of unique policies and procedures, they might not have given that same ability for the substitute case. I like that determination, substitute trading case. But companies are thinking about how are they going to update their policy procedures. What are you seeing in that regard?
Yeah, well, you're right about the fact pattern. I'll get to that in a minute, but I tried before I came up here, went on Google to see if I could figure out or if I could find a prediction of the rate at which the universe is expanding. And the formula is of such complexity that I could be here all night and never be able to express it in words, but it is. And I think that the universe of insider trading exposure, risk, and liability has potentially increased as well, and in ways that may be hard to fully understand given the very limited case law on the topic so far. Now, I'm going to talk about two categories briefly of categories of companies or entities that need to spend some time thinking about the implications of the outcome in Panawat. One are hedge funds. Or any institutional investor that acquires interests in public companies and obtains board seats or through some other means comes into contact with MNPI. I'm a former hedge fund chief compliance officer. We were pretty simple, long-only mid-cap companies. We had seats on several of our portfolio company boards at any given time. So among my many jobs was to maintain our restricted list for employee training and for transactions by the fund. It wasn't a complicated task. It was obviously companies in which we were then invested, and any other companies that were under any level of consideration or analysis by our research group, companies that had been presented to the investment committee pending a decision, any companies in our universe of consideration our employees could not trade in. Post-Panawat, I'm not sure what that list would look like or how I would go about creating it, to be quite honest with you, and I think we're going to need to see some more cases and case law before that becomes clear. I'm thinking of a hypothetical hedge fund, let's say, owns an interest in and holds board seats on a drone manufacturer called DroneCo. And one of the board members learns on a trip to Washington, has lunch with a good friend from the FCC, and learns that unannounced to the public, the FCC is planning a major rewrite of its rules governing drones and drone traffic, where they can and cannot operate, licensing procedures, major impact on the industry. The Drone Code portfolio company licenses software from a company called DroneWare, which enables the hand device to talk to the drone. And its licensing fees represent about 35% of DroneWare's revenue. So I'm thinking that post-Panawatt, it's not a good idea to short that stock. But let's then consider a separate fact pattern in which the software company DroneWare is not a supplier of Drone Code, but a supplier of another competitor, much smaller competitor, startup company in the industry who has an entirely different business mix. It manufactures mostly drones for personal use, whereas Drone Co. manufactures drones for commercial use. Is that a sufficiently attenuated link to cause there not to be a market connection between those two companies, which is part of the phraseology relevant to Panawatt? Are they closely comparable anymore? I don't think we know. It's interesting that Medivation and Insight, the two companies involved in Panawatt, actually weren't competitors. They were both biopharmaceutical companies, both manufacturing drugs for illnesses for which there aren't great medicinal solutions, but entirely different categories of illnesses. They were deemed, because they were both an industry where they were both thought to be prime acquisition targets in the industry because of their status as highly focused emerging companies. The investment bankers dealing with Medivation deemed them to be comparable for M&A purposes. So I think that's really where we are, is how do we define the universe? I think that's which gets down to the compliance issue of how do companies and how do funds revise their policy. I'm sure if you hadn't already, three of you are going to be getting a lot of calls from clients who are trying to sort that out. One obvious answer would be, well, let's just drop a policy like Medivation's that's broadly focused. But I want to read it. You mentioned it, Dan, why this was such an ideal fact pattern for this case. Medivation's policy prohibited not only trading in the company stock while in possession of MNPI, but in those of all significant collaborators, customers, partners, suppliers, or competitors of the company, which seemingly casts a pretty broad net. What's a significant collaborator? I don't know. I guess that will vary case to case. So I think the question for funds and for companies is going to be how to develop and what sorts of analytical tools and legal advice are available to them to help them refine their insider trading policies, and likely, even in the case of private companies now, to perhaps develop or publish restricted lists of their own, or to expand the scope of their blackout periods to companies that might be a close competitor or have a significant market impact relationship with their company. Undoubtedly, advice of counsel will be important. I and my colleagues, and I'm sure our competitors in this room would be delighted if you give us a call, because there's a lot we can do to probably help with analytics around that, economic studies, event studies, looking at correlation or covariance relationships among stock prices of companies that might fall in that universe, major competitor, major supplier, major customer. Are they, as was the case in Panawatt, companies that are in the same industry and thought to be prospective, attractive acquisition candidates? All of those. So I think there's a lot of work to be done, and or there's potentially a lot of work that could be done, and only as other cases develop, if so, I think will the parameters begin to be a little better defined. But certainly something in the meantime, there are some things that can be done to address the risk.
Thank you. A lot to unpack there. Clearly, a lot to still come. All right, so let's move on to a little bit different topic. I think the earlier panel covered some point.
Stole my thunder a little bit.
A little bit there, yeah. But kind of an interesting case from the aggregates point of view, right? I mean, they did talk about the sources point, but what do you think about? One of the questions that's come up a lot in addressing those issues is, is there a way to think about a policy on an aggregate product, whether it's an ETF, a CLO, a swap, where maybe you can set some guidelines at, a 5%, a 10% asset level. I mean, what do you think about those concepts?
Well, I mean, I think this is really difficult because that's so appealing to clients, right? It's a way you can be very consistent across the board. This is something that it sounds reasonable. I just don't think it's going to work with the staff, and I think that's because there's not just a quantitative element of materiality, but there's a qualitative, and that's what the staff is going to look at. The other thing is relying on materiality, that you really want that to be your argument when you go into the staff, that like, oh yeah, they did use this information or they had this information, but it wasn't really material, and so it's okay. I think that, the better approach is to either have, the stock on a restricted list, even if it is a small portion of in that instance, the collateral loan obligation, or have really strong informational barriers that, separate the people that have the material non-public information from the people that are making the investment decisions. And that's hard, right? Because you really need to test that on an ongoing basis. You need to make sure that if you're going to rely on the informational barriers, that those are working, and that someone can't come in and second guess how you had those set up. So while I think clients love the idea of having a mathematical approach that we can take to this, I just don't know that it would fly with the staff.
Joe, let me ask you that just a second. I mean, it does seem with that case that a lot of the issue was the lack of a policy procedure, lack of consideration. I mean, inevitably, when we have conversations with our clients, a lot of it is it material or not? We oftentimes have to rely upon them, they're traders, because they know the circumstances. I mean, is there a place you could see where if clients made the determination on materiality, but got it wrong, that would be sufficient? I mean, is there room for that in the grand scheme of things in terms of the lack of scienter? If you're consulting, I always tell folks when in trading, like, the first thing to realize is no SEC case begins after consulting with counsel they traded. I mean, how would that play, would you think, in a presentation to you all?
It would obviously depend on the facts of the case. I mean, I think Lee addressed this earlier, and I think you're right that the case was a 204 Cap A case. It wasn't an insider trading case, right? So there's no allegation of insider trading per se. The issue was around the policies and procedures. If you have policies and procedures that are in place, and those policies and procedures are working by identifying the issue and the trader having a conversation with the compliance officer about whether or not they can do the trade, then I think you've got a good story to tell about your compliance system. But if there are no policies and procedures, or the policies and procedures are not enforced in such a way to sort of bring that conversation to the fore, then you've got a less good story to tell. Great. Sorry, I mean, that's maybe
No. That's helpful. Thank you. All right, so let's switch gears here a little bit. Sarah, there's been a lot of discussion in speeches and other places about 10b5-1 plans. Not always maybe going to be the silver bullet, things like that. There was the case that was filed earlier this year, and then a change in rules that have, in some respects perhaps cut back the ability of folks at public companies in the same way they had in the past to use 10b5-1 plans. Maybe give us a little bit of sense from your read and how you're thinking about this, the significance of that case and how that might be changing things going forward.
Sure. So Dan, I really think about it. You're talking about the Pizer case.
Yes.
We think about that as 10b5 plan trading gone wrong, almost like a fact pattern of what not to do. And just to kind of take a step back, I think around 2000, the Commission kind of launched a 10b5-1 plan through its rulemaking. The idea is if you trade as part of the plan a preset time while you're not in possession of MNPI, you have an affirmative defense for insider trading. And so, in some ways it's an efficiency. If something hits Joe's screens and there's some follow-up and we see it's an insider and there was a plan in place and the trading met those parameters, hopefully Joe can move on with his day. And there was some, various criticism. Academics looked at trading over time pursuant to insiders as part of 10b5-1 plan trading, and felt that they had evidence that the trading was more successful than if it was random. And then there was criticism that you could still trade pursuant to those plans through avoidance. Right? Like you could have the plan in place, think you're going to, you're an insider, you learn something that's MMPI, decide not to trade. And other ways, perhaps manipulate when you're releasing good news or bad news, even though your plan, the trading, the timing is set. And then also there was discussion about use of multiple plans through different time periods, some type of stacking that was manipulating. So, as ever, the resourcefulness and creativity of our markets, continues. And under Chair Gensler, the commission put in place amendments to the rule. So they looked at imposing greater cooling off periods. So for directors and officers, a 90-day period, you set up the plan, you wait those 3 months before you trade. 2 days have to pass, business days after, a quarterly or a financial reporting announcement before you trade. Some guardrails in place. More disclosures, an annual disclosure about plan trading, quarterly disclosures. You had to make an express representation. I don't possess MMPI, and I'm entering this plan in good faith. And then you're no longer allowed as an individual to use stacking of 10b5-1 plans. So it was a relatively straightforward rulemaking for this period of activity. And this case really highlighted sort of exactly how they still shouldn't be using this type of trading. And it was brought SEC and DOJ. So as those of us who came out of the trial unit know, SEC was stayed, DOJ went forward, and there was a criminal insider trading case against the CEO and chairman of a publicly traded healthcare company. And he basically had learned that one of their largest customers was likely going to terminate from working with them. He set up a plan, a 10b5-1 plan, and he traded right away. And then he learned that they were pulling out, like actually happening, a couple months later, and did the same thing. Entered into a plan and traded the next day. Against advice of compliance professionals and attorneys, as alleged by the government, and he avoided $12 million in losses by doing that. And so, the lesson is really clear. An affirmative defense is not a green light while you're in possession of an MPI to actually trade, but it also speaks to, you said no SEC's case starts saying after consulting with lawyers I traded. Unfortunately, there are quite a few cases that are after my compliance people and my lawyers told me not to, I traded. That's not the path you want to be on. So I think it's helpful to know about because, it can be hard for in-house counsel to persuade, especially, he's the CEO and chairman, that these rules matter or the cooling off period is meaningful. So the fact that they were able to get this criminal conviction, I think the sentencing is in February, can be kind of helpful in counseling what not to do.
No, that's great. I mean, one of the things that I've wondered about, because there's a lot of situations that come up in the course of talking to clients where, they don't have the formal written 10b5-1 plan, but you apply those concepts. A swap is going to roll. Maybe there's a trade that's kind of been, it's a little bit more stretched out in execution. I'm wondering if the nature of that case or even the change in rules, which, I think some have, whether starting with the academic study or some of the speeches have made really start to question the validity, whether the staff believes fully in the validity of 10b5-1 plans, have changed how you're advising clients in those, let's call them informal 10b5-1 plans in their approach.
Absolutely. I think there's guidance we could take. We see the factors that were important to the commission to put into the rule amendments, cooling off periods. Put time between you when you're setting up the plans or, let's say, when you learn of the MPI, you believe there's no longer MPI, put a little more time between you and that period if you're really not trading on the information. And I'm sure we all had experiences with insider trading investigations, but usually at some point your client has to put forward, an explanation. What What is the evidence? Why did you trade at that time? So what does that record look like? But I think looking to these amendments absolutely is a cautionary tale. So, insiders have to be careful. It's just the reality.
Yeah, I agree with you that we've heard this at a couple of the panels. The documentation you put in place at the time, even if it's not a formal plan, but some rationale, thesis, whatever it may be, that can be gold when you're later sitting in front of the staff.
A series of Google searches all done on the same day, kind of after the subpoena arrived, not going to be too helpful.
Yeah.
Not that I may have seen that,
Of course not. All right, so let's move on. All right, so the change in administration, we've talked about that. Obviously, it's impacting a lot of things. And what you see is people coming out, maybe becoming consultants, people going in that had been your colleagues or your clients' colleagues, and now they're talking to them. Joe mentioned the Thompson case from the Federal Reserve employee. There's the old CMS case, Blasiak, from several years ago. What, if anything, Caitlyn, are you seeing as it relates to government information sources and how folks are dealing with that? Thinking in the context of the change in administration, where new opportunities, if you will, might be coming around.
Yeah, I think that one of the things with the Blasiak case was that prosecutors emphasized right when they brought it that just like trading on material non-public corporate information can be a federal crime, so can trading on secret government information. And so I think although that case, and we can go through it, but it's been up and down and it went a lot of different ways, I don't think much has changed in terms of if there's government information and the right fact pattern exists, that's something they're still going to want to bring. They're going to want to bring insider trading cases on. Now, it's a little more difficult. I think that the Bridgegate threw a little bit of a wrench into that in terms of bringing a securities fraud action under Title 18, because now they have to deal with what is property in a way that you don't have to under Section 10B. And so I think if we are going to see some more cases brought on non-public government information, they're likely going to be brought as 10B cases. That's what I think. And then you've got to prove the personal benefit, which they weren't able to do in the Blasiak case. But it's just, I think that the hurdles that were put in place on Title 18 securities fraud make it a little bit more difficult with the government information, but that only applies to government information, not corporate information.
Right. There are those extra factors, right, that exist with the personal benefit. You mentioned that, sometimes do come up towards the end. It seems like after you've already established the information's there and there was the trade that you need to put in place. Okay. All right. That's a helpful background. All right, so let's jump a little bit to crypto. The SEC has done a lot with crypto, and we've heard on various panels how some of that some of that activity and focus might change. But what about in the insider trading area? As it becomes perhaps maybe a more accepted asset class out there, should we expect to see more insider trading cases, Sarah, or what's your expectation?
So enforcement's on it. They've already brought, as many of us know, under Chair Gensler, they brought the first insider trading case related to digital assets. It's the Wahi case, Ihsan Wahi. It was brought also parallel proceeding SEC DOJ. What was sort of interesting is DOJ charged it as wire fraud, and SEC, was traditional insider trading 10B of a security, and it looked like, at least from the outside, that DOJ didn't want to tangle with the legal issues of whether what was involved was a security or not, so had sidestepped that, but basically it was the same case on the same facts. Very briefly, was product manager in Coinbase, Mr. Wahi, whose job it was, he knew what assets were going to be listed on Coinbase's exchange before they were actually listed. And he got the information, he tipped his brother and girlfriend. I think there were at least 9 different trades. I'm sure Joe could correct me if that's wrong, but and they made money, and the government brought cases. There was some, I think there was Mr. Wahi was on his way to his plane to fly out of the United States to India, so there's some drama there, but was stopped. And they ended up pleading guilty. What was interesting to me was when you're looking at the case, how did this surface, right? Because never underestimate the data analytics of the commission, but were they able to see, Coinbase, did they have visibility into that? And I guess in the public reporting, there was a source that tweeted that there was a wallet that had purchased hundreds of thousands of this, what I would call token or asset, before it was actually listed. So there was a tweet that brought that out publicly, and then Coinbase responded, and they identified their own employee. And just what's interesting about that is, as you're saying, Dan, there's tremendous focus. I'm based in Washington on the regulatory changes coming for crypto. But once those pathways emerge and are clear, we would expect that the commission and enforcement will, part of the sign of kind of getting through that thicket will be normal enforcement cases being brought if you get past regulatory disputes, and to the extent these are securities, we'd expect to see insider trading cases. So it is interesting to think about how will enforcement use its tools to have visibility in ways that, is there blue sheeting in these types of assets? Perhaps, but it's just a whole other frontier.
Yeah, I mean, I know, it seems like once you move outside of the traditional equities, there is always that concept of, whether or not it's going to be observable. And oftentimes it seems like you talk about that perhaps as a mitigation. If you get the closer calls on materiality, the ability as to whether or not that's going to be, we think about investigation risk, that's certainly a part of the discussion, it seems like to me. What about market manipulation? I guess, some of that comes back to, whether we have a security or a commodity, whether it's the SEC or the CFTC that fits into that. Is that something that we should be thinking about and expecting in terms of crypto assets?
I mean, I don't know if Joe wants to comment.
Well, just to maybe a little bit of commentary on the Wahi case is that you mentioned there were the 9 securities. The 9 securities in the SEC complaint were the crypto assets that were traded that the SEC in that case alleged were securities. There were others. I think there were 25 in total. So 9 out of the 25 were where we alleged that those were securities, and so that was the line in that case. And I don't want to speculate going forward, whether a new commission is going to take a different view of what's a security and what's not a security. But that was the line there. And I think it's always going to be an important line. The question is, what is the answer there? And again, that's for this new commission to decide.
It seems like in the manipulation context, right? Thinking about the individual that Grabir mentioned earlier that lost all of his $400,000 invested. It's a sad story. Seems like a really bad investment idea. But the manipulation is something that you see a lot of complaints about from the folks that are in the market. And in the same way that the securities are there, I would expect that on a going forward basis, that's going to be, just as a big of an issue. Whether it's a currency or whatever. Manipulation is an issue on the plate always. Okay. All right. So we have a few minutes left out. I wanted to raise the issue with respect to loans, just as an additional topic here. The Sound Point case touched on it a little bit with the CLOs. Obviously, it was an equity tranche in the CLO. But the loan trading is a place that seems like it again, with the increase in the credit markets and the focus of a lot of different clients on the credit markets, how to deal with MNPI in the world of loans, which are not securities, right? There's court case after court case would say that. There was the Kirshner case that was up at the Second Circuit. It seemed like the SEC was going to submit a paper in that as to whether or not those were securities or not. Press reports out there indicated that the Security General's, or excuse me, Solicitor General's office suggested that you need to get buy-in by a couple of other federal agencies, I think the Fed, the OCC, and perhaps that didn't work out. Again, that's what's been reported in the press. But it does seem to me that that's an area that's going to get some attention in terms of, perhaps a bad facts, bad law circumstance and going forward. Picking up again what was discussed in one of the earlier panels with respect to maybe creditors committee, ad hoc groups that then have information to go out and trade in loans, a place where big boy letters have a fairly big component. I'm curious if others on the panel have had interactions, and Joe, I'm not asking you to comment about the potential for it, but others in terms of interacting with their clients on that, Sarah, Caitlyn, or Norman, is that something that you've been dealing with at all in addressing with your clients?
I have not yet encountered it, no.
Okay, all right. Well, so
we'll talk about it on next year's panel.
We will. All right, so I think with that point, absent anybody else, Joe, you want to finish this off?
One more thing. So I mentioned before trying to be open to, the data and sort of follow it, the evidence where it leads. One of the themes that has kind of emerged over the last few years, and it's funny because we were talking about this at a panel that was a remote panel or a virtual panel in 2020, is what is the impact of telework going to be on insider trading, right? So I was, sitting there with Dan Hawk and Rob Cohen, who were my former, chief and co-chief of the market abuse unit. We're kind of speculating about it. And, it didn't take a genius to realize that there were going to be more opportunities for insider trading. And I think, we've seen that. So in 2022 and 2023, the SEC filed 3 cases that I'll kind of characterize as spouse or domestic partner trading on information that they either overheard or saw on the computer of an insider, whether that be a marketing professional who had information about a takeover, or a person who worked at an investment bank who had information about corporate mergers and acquisitions. And so that pattern, right, even though, the sort of the darkest days of COVID are behind us, telework is still a thing. And in 2024, last year, we filed 4 cases that I would kind of put in that category of, trading on information, belonging to a spouse or domestic partner, where you're working at home. And so I think this is going to continue so long as telework continues. And the thing that I would say, to people who possess material non-public and have, domestic partners or spouses is that, you really need to safeguard that information. Everybody thinks that their, spouse or domestic partner is trustworthy, but, these cases kind of speak to the contrary. And the consequences are pretty significant. So in one of these cases last year, an individual, Tyler Luton, traded based on information about an upcoming merger that his wife was working on. He made $1.7 million. But after the case was brought and there was a parallel criminal case, he was sentenced to 2 years in jail. So it's, the consequences are serious. The need to protect material non-public information is serious, and I think it's going to be an ongoing challenge.
And are you seeing those cases more in the mode of a hack, in that the partner who has the information might not know that their significant other is misusing their information, or is it a little bit of a tip, or both, or you're not drawing those distinctions very closely with, household bliss in the middle?
It's, the fact finding on that issue is always challenging, because you can imagine there's a certain amount of sort of the trader falling on their sword with respect to what happened. But I do think that, in some cases, that it is quite genuine, that the individual who was, working on the deal or whatever else, was perhaps, on a telephone call or something that could have been easily overheard. In that Luden case that I mentioned, the couple had home offices that were 20 feet away from one another. So it's kind of an easy thing to see how that could happen.
All right, I think that is it now for us, and we'll give our fearless leader a chance to tell us where we're going next.